The restriction refers to the use of the property, not whether there's a house on there or whatever.
Everything Mr. Ranford brought up was made up. Now they are violating my basic property rights. I spent more than $415,000 on the house.
Michigan law does allow people by contract to have restrictive covenants established, and then those run with the land. And these do have, there is a document called protective covenants. All right, so we've got Mr. Losnick here for plaintiffs, or for the plaintiff, Holiday Subdivision, and Mr. Changi Zhu representing himself. Mr. Zhu, good morning, sir. This is your motion, sir, for, it looks like a motion to either vacate my order granting summary disposition to the plaintiff, or in the alternative to grant you a stay of that order pending the appeal. And I see that you have filed an appeal at the Court of Appeals. So I've reviewed your motion and the response. Anything you want to say in support of your motion?
Okay. Good morning, Your Honor. So first of all, this is an unlawful lawsuit based on my knowledge, just because Mr. Ranford illegally filed this lawsuit without the consent or knowledge of the vice president of the association, and also Mr. Ranford, and also with his wife are holding two key positions, vice president, vice treasurer. So they can manipulate the association in such a way they didn't disclose their actions to the association, to the regular members of the association.
So Mr. Zhu, that argument was made at the time that I granted the motion for summary disposition. And I said then and believe now that even if that's true, that's a matter for the subdivision to pursue remedies and relief. You know, that really isn't, you know, if Ford Motor Company sues you, you know, you saying, well, gee, but Ford Motor Company, some of the majority shareholders don't agree with this lawsuit. That's a matter for Ford Motor Company to sort out, right? The defendant side of the lawsuit doesn't get to insert themselves into the corporate governance of the plaintiff, right? I mean, why would that matter?
That's a different analogy. I would say this is opposite. If a Ford, let's say, motor company sues, let's say, a defendant, in that case, that's the corporation. If the president of the Ford company decided to sue, let's say, a defendant without the knowledge of Ford company, that's wrongful lawsuit. That's right, illegal lawsuit.
I guess what I'm saying,
this is the same.
I guess what I'm saying is you don't have standing to complain about whether Holiday Subdivision is acting properly under its governing corporate structure. That would be something for folks who are. Yeah, we already addressed that. You've already lost on that point.
So we're not here today to just because I appeal this ruling at the Court of Appeals, and I don't know who is the plaintiff right now. The plaintiff is unclear. So basically,
the plaintiff is still Holiday Subdivision.
It's unclear.
No. Plaintiff is Holiday Subdivision.
No, it's not. Basically, vice president doesn't know this. And didn't know this lawsuit. And also Ranford is manipulating his power.
Okay, Mr. Zhu, I already ruled against you on that.
Okay, that's okay. I temporarily accept that. Okay. And also the other argument for the ruling is based on the covenant. The covenant obviously was about the initial setup of the Holiday Subdivision. It didn't mention any house use at all. And that's a dispute. And basically, Mr. Daniel last night argued that you can't separate the house from the land. For sure, you can separate both, but land is land, lot is lot. The land and the lot are not equal to the house. If I want to buy a house, you sell me a land, I won't accept that. I only want to buy the house. That means I buy the house. I'm not buying the land. I'm not buying the lot. So basically, if we look at the covenants clause, there was no single word about house use. And basically, any extension of that meaning is misinterpretation.
So, Mr. Zhu,
yeah.
if I'm starting from a blank slate, you know, let's say even I found your argument persuasive about that. But at the motion for summary disposition, I cited the 2023 Michigan Court of Appeals published case that's binding on me, Aldrich v. Sugar Springs Property Association, where the restrictive covenant stating all lots in the development shall be used for residential purposes only did in fact bar short-term rentals.
That's different from this one because we have to read
What's
the
different?
covenants of this one closely. We can't
This one
reference the other one. That's different.
Right,
The covenant is different from this one.
Okay.
I can't accept that just
okay.
because that's
Let me ask you a
totally
question.
different.
Let me ask you a question. This covenant says no lot shall be used except for residential purposes.
Right.
The covenant in Aldrich said all lots in the development shall be used for residential purposes.
And
what's the difference?
Basically, we just focus on this. I have a question. Does this covenant specify the house use or not? Does this covenant from holiday division, does it restrict the house use or not? I have a same question to you. Does it restrict? I don't care about the precedent.
Yes, it
basically.
Well, okay, so that's
no
what we're
house
getting at.
use. There's no house use in the covenant. We can't misinterpret it.
So, Mr. Zhu,
I'm not violating any law. I'm not violating any covenant. I'm not violating any rules.
Okay, Mr.
Instead, it's
Mr. Zhu.
Okay.
Okay, this is a civil case.
Yes.
But if you disrespect the court and interrupt and talk over me, it can become contempt and you can go to jail.
Okay.
So let's not have that happen. Let's not have that happen.
Okay.
So this is the rub of the issue. You say, and you just said out of your mouth, and you've said in your motion that you disregard the precedent of Aldrich. I don't have that discretion. I must follow Aldrich. You haven't explained to me why this covenant is different from that in Aldrich. And under the Aldrich case, you lose. And so I must follow the law. So why is Aldrich different?
Why? Because you can compare something like this. You see, okay, that orchard has apples. Those apples were bored by worms. So your orchard must have also worms. Your apples can be sold to customers because you also have orchard. You also are growing apples. That's the same analogy. I can't just respect the ruling by borrowing some other decisions. We have to look at my case closely. I can't buy that analogy. Basically, the whole ruling was not logic at all. Basically, Mr. Dan last night, basically he didn't bring up any original lawsuit issues against me in the last hearing. He didn't. He filed all the basically summary disposition based on other rulings. And that's irrelevant to my case. My case was not discussed adequately.
It is not irrelevant. This is
irrelevant.
It is
irrelevant. Basically, that's irrelevant.
Precedent is not irrelevant.
We have to discuss my case. My case was not discussed last time accurately. Okay. Accurately and adequately. That's why I filed the motion to vacate that court order.
Okay, thank you, Mr. Zhu. Mr. Lasnik, your response?
Yes, Your Honor.
Aldrich
I
compelled
thought I was here on a motion for stay of the order.
Yeah, I mean, it was captioned as a motion for stay or motion to vacate, okay. but really he's saying that I don't have to follow precedent, which of course I do.
Well, yes. Just a couple arguments. The restriction refers to the use of the property, not whether there's a house on there or whatever. Short-term rentals in a tent or a house is the same. House goes with the property. Anything permanently attached with the property goes with the property, and it's part of the property. As to the stay, this is a discretionary call by the court. that looks at the factors such as, one of the factors is chance on appeal. As the court noted, there's a Court of Appeals decision right on point that says you cannot use short-term rentals for deed restrictions that can apply to residential use only. So that's weak. As to balancing the harms involved, there was a claim that the finances of the situation makes it impossible for the defendant to maintain the property. There's been no proof submitted also that he can rent it longer, meaning he can rent it for more than 6 months, or he can sell it. So there is another avenues for him to take, minimize the financial harm. And then the final thing, the deed restrictions are a contract that need to be enforced so that anybody that develops a subdivision or has common property that he develops and wants deed restrictions, then the public needs to know that these are enforceable. And so the public harm, but again, would weigh in the favor of the plaintiff. So using your discretion, I would ask that the court deny any stay on appeal.
Thank you, Mr. Laston. Mr. Zhu, any rebuttal arguments, sir?
Okay, I can see Mr. Daniel last night's rambling argument, because all his argument is weak. Is very, very, very weak. Why? He can't see what I violated. He can't see that. He said the association is deed restricted association. That's not the fact. Basically, I talked to vice president of the association. The vice president, Mr. Tim Reed, dismissed that argument about deed restricted association. And also, this association is voluntary association. Not every household needs to be part of the association. It's voluntary. And basically, there's no documented statement about deed restriction. Everything Miss Ranford brought up was made up. And also Mr. Daniel last night was defending was a false story. And basically the association is not paying a single penny to my house. Now they are violating my basic property rights. I spent more than $415,000 on the house. Now he simply says I can't use it for what? So basically, can I just file a similar lawsuit to my neighbors? I say, you can't do this because you are engaged in certain activities in your house. I don't allow that. So basically, I'm not violating any law, any rules, any covenants. That's the fact. So basically, the association is not the restricted association. It's made up. There's no fact about it. We can look into it. So at the Court of Appeals, I will argue for that. You need to bring up the documents, put the documents in front of the judge and then in front of the camera to show me the cause, why it's a deed restricted association or not. It's voluntary. And you can present the bylaws to the judge. And what restriction the association has? No, none. There's no restriction.
Mr. Zhu, address your arguments to the court, not to opposing counsel.
Okay, thank you.
Anything else I need to know to understand your position?
So basically, I think I made myself clear. Thank you. Give me this opportunity time. Sometimes I'm emotional because I thought I'm correct. I didn't do anything wrong. Instead, I'm putting in an adverse position. And I need to spend so much time, so much money on this. I have genuine basic interest in serving people, helping people out, paying people with my little money. And I'm not getting money. I'm losing money just because I really need to. Basically, I have time in summer. And if I don't do anything, I would be, really waste of this time. And I also want to show my son and I can do something meaningful to the society. That's it. I just don't want to be on the tennis court for the entire summer. Instead, I'm paying my cleaner, let's say $1,500 or $2,000 for a month. And without my property, this cleaner with daughter can't earn that much money. And basically she and her husband really need money. They are basically laborers, and without this opportunity, they don't have other job opportunities. I'm just subsidizing this type of thing because each month I need to pay more than 2,000 on mortgage, and also property tax is high. I pay 5,000 property tax on the property to support local economy. So basically, I'm not doing anything bad to the local. I made so many to the local people. I made so many friends, and the contractors are helping improve the conditions of the house. Without any type of rental income, the house would deteriorate because of flood, because of damage to the roof, and because of the deterioration of the deck whatsoever, and then it will crumble to the ground. And basically, my purpose was to stay in the community, basically to be part of the community. I'm not trying to violate any person's interest, any community's interest. Instead, I want to be helpful, to be part of it. That's it.
Okay, thank you, Mr. Zhu.
Thank you.
Well, Mr. Zhu has filed a motion for me to either vacate my order, which had granted the plaintiff's motion for summary disposition, or to grant him a stay of the effect of that order while he takes his appeal. Mr. Zhu makes some very impassioned arguments for why his activities in using his property as a short-term rental are a good thing for the community and for his neighbors and for himself, and not a bad thing. He may well be right as a matter of policy. And if we were at a subdivision meeting deciding whether to adopt or amend a restrictive covenant, those are very important arguments about that not just the benefit that can flow, but the rights of people to use their property as they see fit. Those are very strong interests. But Michigan law does allow people by contract to have restrictive covenants established, and then those run with the land. And these there is a document called protective covenants. It's not a made up fact. It's a recorded document in the Register of Deeds in the county of Sheboygan. It's a document of record at Liber 280, page 397 and 3 through 390. Well, at page 397 is where it starts. And on that page, it says, no lot shall be used except for residential purposes. There's no dispute that this lot is in that subdivision. It is, in fact, subject to that use restriction. Mr. Zhu has argued that because it doesn't refer to the home, but only the lot, and for some other arguments, he says that he's not in violation of that. As this court noted at the previous hearing, the Aldrich case in 2023 demands a different result in a very similar and really an indistinguishable restrictive covenant. That court said that short-term rentals were not allowed under that. And I know Mr. Zhu thinks that I should not follow precedent, but in fact, under our legal system in Michigan, I must follow that precedent. I would be violating my oath to disregard a binding case from the Michigan Court of Appeals. So I must follow that. So I'm not going to vacate my order, and I'm not going to stay the order on appeal. There's been no argument put forth that would show that there's any viable claim that Mr. Zhu would have on that appeal. So I'm denying your motion, Mr. Zhu. The court order that I entered is in effect. You can't, I've filled out an order denying it that I signed that I'll file today. So you can get a copy of that. You can ask the Court of Appeals to stay my ruling, and they'll want to see a copy of this, and you'll have to order a transcript of today's hearing. But you can ask the Court of Appeals to stay my order pending appeal, and then it's up to them. Okay, but I'm going to deny your motion, sir.
Thank you, Your Honor.
All right, thank you, everybody.
Thank you.